Due Process, recipient of 2 Mid-Atlantic Emmy Awards for Outstanding Talk Show Series and Outstanding Public Affairs Series.
I can't say anything now. I'm sorry.
Okay. This convicted child molester served his time. Now the law says his neighbors should know he's in their midst. But when his face wound up on page 1 of the local paper, it took community notification to a whole new level. Just weeks after the law finally took effect, is it already out of control? Megan's Law on this edition of Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.
It was passed in the wake of one child's horrible rape and murder. It was challenged for nearly 3 years in the courts, and it was finally cleared for full implementation just this last December. I'm Raymond Brown, and we're talking, of course, about Megan's Law, which is now raising new controversy. The sticking point still is community notification, but now there are First Amendment questions, too. We'll get some very different answers from a media law expert, from a Megan's Law opponent, and from New Jersey's Attorney General. But first, here's Sandy King to fill us in on the latest flap. Sandy?
Raymond, let's begin with what Megan's Law is. It takes convicted sex offenders post-release, and it purports to protect the communities they return to with a 3-tier system of notification. Tier 1 targets just have to register with police, while Tier 2 people face the greater exposure of institutional notification, schools and such. But the Tier 3 offenders get the full treatment, where they live and where they work, a door-to-door notice to their neighbors, too. It may come in the form of printed flyers, as in Union County in the last few weeks.
I can't talk. I can't say anything now. I'm sorry.
He's one of only 48 men in the state who've been classified as Tier 3 sex offenders. Under Megan's Law, that means his neighbors get the word. But when the local paper put that word on its front page with his picture, notification, some said, had gone out of control.
It moves beyond what the court said was appropriate dissemination of information, because when something is given to a newspaper and it's published on the front page, that publication goes far beyond the likely to encounter zone of notification.
But while the Attorney General was outraged by both the Home News Tribune and the source of the leak, longtime Megan's Law opponents were saying it was just what they had expected all along.
And although this is too serious a matter to say I told you so, I think it is. I think it should cause everyone involved with Megan's Law to reflect and see if these notifications are going to go on, if there's any possible way to prevent this from recurring in the future.
It does mean that much to me. That's why I've come forward.
Other Megan's Law targets, like this man, whose challenge to the law would finally prove unsuccessful, had gone public voluntarily or had been ID'd by private folks. But this was the first case of a Megan's Law offender being outed in the media as direct result of the official process. And the Home News Tribune's editor was making no apologies.
Had been an issue of some public concern, as you well know, the whole Megan Laws thing. But no, we didn't hesitate about publishing the story.
Though it was signed into law more than 3 years ago, appeals kept the measure on hold till late last year, when a U.S. Supreme Court justice gave the go-ahead for notification. So flyers like this one have just started to appear in those communities where offenders deemed Tier 3, potentially the most dangerous, live and work. One of those flyers came to this man's home.
You know, you never knew something like that, and you never even thought something like that could happen. You see it on TV, and there it is, right around the corner from you, 1 block away.
on this quiet street where this man lives with his mother. He was convicted twice of sexual assault and paid for his crimes with years in prison. His lawyer says he should not have to pay again.
Yes, he committed a crime. Yes, he paid his time. That was in the early 80s. Whether he is a menace to society at this time, I'm not a psychologist. I don't know his background.
The man's most recent crime, an assault on an 8-year-old, was actually a full decade later. His release just 1 year before Megan's Law was signed. The law says his neighbors should know that he's around, but that they should not tell anyone else.
It may very well be too much to expect that when you engage in such widespread notification, even if it's only to the surrounding neighbors, that human nature is not going to drive at least one or some of those people to engage in improper disclosure.
But the Attorney General insists it is not too much to ask, and he says he's prepared to bring sanctions to ensure confidentiality if requests for cooperation don't work.
The notices actually occur as part of a court order, and within the court's order itself, there is a contempt provision.
But would the state actually prosecute the person who shared this flyer with this paper?
Could be charged with contempt of court, which carries fines and possible incarceration. That ultimately would be up to the court.
And what about legal consequences for the paper?
You know, there is no law that prohibits us from publishing this information. This is public information. The flyer itself is distributed publicly.
We call on all citizens, including members of the media, to abide by Megan's Law, both the spirit of the law and the letter of the law.
We decided for this report not to use the man's name or face, and not because we feared prosecution.
Decisions of the Supreme Court and the courts suggest that there's nothing that can be done against the newspaper legally. But the person who got the information from the state, understanding that it was not supposed to be disseminated, who then disseminated it, it is possible that person could be subject to some type of criminal prosecution or contempt.
But the editor of the Home News Tribune says he'll run names and pictures again.
And I certainly hope they don't try to prosecute the person who gave us the flyer, assuming they find out who it is, and, you know, we're not going to disclose that identity.
So is it, as opponents had warned, a case of flawed legislation?
One of the explicit assumptions that the state Supreme Court made clear in its decision when it upheld Megan's Law is that it expected that the media would not do this and that people would not divulge information improperly.
Were those unrealistic expectations on the part of the court?
Well, a lot of people thought so at the time. Now, in all honesty, yes.
So we went back to the 1995 opinion from then Chief Justice Wilentz that upheld Megan's Law, at least at the state level. We note the First Amendment problems, he wrote, in any attempt to restrain or punish the exercise of free speech where the actor is an ordinary member of the public. And as for the media, he wrote, we assume the media will exercise responsibility in the matter, and we assume that the media will not knowingly frustrate the explicit legislative goal of confining notification to those likely to encounter the offender. Raymond, might that indeed have been a flawed assumption?
Sandy, it seems to me that any statute that relies for its enforcement on the goodwill of the media to pass up what it regards as good stories is in deep trouble.
Well, relying not just on the media, but on ordinary folks. Is it too much to expect that someone who gets this kind of information will keep it from friends, from families, from people they work with? Isn't it just the kind of thing that people will talk about?
Sandy, if that analysis is true, if those questions are valid, then what does the future hold for the future of Megan's Law? We're going to get one answer from Attorney General Peter Venero, another from a longtime Megan's Law opponent, and maybe a third from a lawyer who's an expert on the First Amendment. You stay with us.
If you got a convicted rapist or something living next door to you and you know it, I don't think anyone could hold that back and keep it a secret.
I could keep it a secret. I don't know if I would, depending on the kind of offense and, you know, if I wanted my neighborhood to be safer.
I think I could, but I know a lot of people that couldn't.
The only people that need to know are the people around, and nobody else really should know or care about it.
If something like that gets out, I think you'd want to tell your friends, and friends will tell friends, and then be a community-wide thing.
Depends on what, if explicitly what the law says. If the law says it's supposed to be kept confidential and for the neighbors, then I really think you still have to uphold that part of the law.
But will most people who receive the notification be that scrupled in how they respond? How will most of us in the media react? And what does it all say about the future of Megan's Law? For some answers, we turn to Attorney General Peter Vernero, to defense attorney Jack Furlong, who's represented over 50 John Does under Megan's Law, and to media lawyer Peter Banta, who's chair of the State Bar's Media Committee. Gentlemen, welcome. Attorney General, I've got to turn to you. I think the ball is in your court. Doesn't this all mean that this statute is fatally flawed?
Oh, I don't think so at all. I think most people want Megan's Law to succeed. And if that means that they have to abide by the confidences, which are designated as part of the law, I think most people will abide by them.
But isn't it fair? Well, what we know is that the Home News Tribune and the person who gave them the notification have already violated the spirit of the statute and have really done what the Supreme Court promised it wouldn't happen as a condition, in effect, for justifying the statute.
What happened in that case, frankly, is very disappointing. And it is not what we intended when we enacted Megan's Law. I actually had a very good meeting with several newspaper editors in my office recently, which we spoke candidly about the statute.
Did it include the Home News Tribune?
It did not,
okay.
But it did.
Because their position is they'll do it again.
It did not include the Home News, but it did include the head of the Newspaper Association in New Jersey, the Press Association, speaking on behalf of all the papers, and the editors of the Star-Ledger, the Asbury Park Press, which is affiliated with the Home News, and several other papers. I'm optimistic that the media will act responsibly.
Did they give you a hard, fast commitment that they're never going to do it again?
And
in fact, the Ledger, in fact, did run this very same story with pictures, as did NJN, although we didn't do process.
Well, the papers ran the story after the Home News did,
right.
So that
But it further disseminates the same information.
It did.
Well, Jack, you've been criticizing this statute from its inception. I know you won't say I told you so in a self-satisfied way, but is this one of the things that you were concerned about?
I told you so, and I say that in a self-satisfied way. When Mr. Vernero says that he'll put people in jail for contempt of court, I'm reminded of the two vigilantes who actually attacked the wrong man up in, I think it was Phillipsburg, broke his jaw. I think one was a corrections officer in Pennsylvania, if memory serves, and they were let off with what I'll describe as a slap on the wrist. I think the correction officer resigned his position, and I think they were placed on probation in order to pay a fine. That's for actually assaulting the wrong man and breaking his jaw. Now, for publishing a name or giving out a piece of paper, I guess the fine will be something on the order of don't do it again, and I mean it.
Before I bring Mr. Banta in, Attorney General, are you willing to get meaningful sanctions? Are you willing to send newspaper editors to jail?
Jack doesn't speak for my office,
okay.
And the case that he was referring to is part of a judicial process, so I can't comment on that.
But in a future case, if the Home News Tribune calls you up and says, we're going tomorrow to run the story, are you prepared to invoke sanctions against them?
Well, the law does not expressly govern the newspapers. The law governs those who receive the information. These notices are...
What about the guy who's giving it to them?
Well, let me just explain, because I think your viewers need to understand this. Before you put out a notice, the prosecutor goes into a judge and describes what he or she believes should be the zone of notice, the scope, the parameters within the community. And if the judge agrees, he issues an order allowing that notice to occur. In the judge's order, there is a contempt provision, which says, in essence, if you, as a receiver of this information, disseminate it improperly, if you give it to a newspaper or give it to someone else who's not entitled to know, then you are liable for contempt. That decision, whether or not to prosecute and so forth, will be a local decision made by the county prosecutors. I have made my position.
Your office has defended this statute. Yes. As a matter of policy, are you going to urge prosecutors to seek to sanction the people who give the notice to newspapers? Are you going to supersede prosecutors who don't, which is within your authority?
I have urged the prosecutors in this case to find out who did it, and yes, we will take the appropriate course of action if and when we do. As to vigilantes, I've been very clear, and the governor has been equally clear, we will not tolerate any vigilantism in connection with this statute.
Peter Banta, let me bring you in. It seems to me that the fundamental threat to this statute, as it's at least been interpreted by the Supreme Court, comes because we have a First Amendment. Are there any limitations you think that could be put into a statute that would prohibit publication of this information by newspapers?
I think it's very limited what could be done. First of all, I have to make a mandatory disclaimer. I'm chairman of the State Bar Media Committee. I'm not officially speaking on behalf of the bar because only our Board of Trustees can speak. That's for identification.
Now we want to know
only,
what
as
you
they
think.
say.
We didn't want to
But
know
I
what they
think-
thought anyway. We want to know what you think.
I think we go back to the statute. First, the statute addresses only the conduct, as I see it, of the government agencies in making dissemination. The Supreme Court, to save the statute in Doe v. Poritz, in effect said, we're going to imply a further obligation on the part of people not to further disseminate, and we trust the press will be responsible. That's not in the statute. You now are talking about a court order in a secret proceeding to which the press and public are not party, threatening contempt to housewives and others who may disseminate this information. I think this is outrageous, and I think
let me go through two steps. Let me go through 2 steps with you, because I know the Attorney General wants to respond. So, number one, if you're called by a newspaper and they ask you, "Can we go ahead?" Your view is, under the statute, there's no prohibition.
That is correct.
And now, suppose the housewife who wants to give it to the newspaper calls you, what's your advice to her?
I believe that if she is acting according to her view of what is persons likely to encounter this person, and she is distributing it further to them, that she can do it.
Oh, that's a different issue.
Well, does she have the right to decide?
That's a different issue. What is getting lost in this entire debate is the fact that the law in several other places, aside from Megan's law, has places where we must keep information confidential. Let me give you some examples. The names of juvenile offenders, the names of rape victims. I mean, the law carves out exceptions to dissemination in many different areas.
Can I just one point to you, Attorney General? Yeah. The examples you gave are examples where the public is generally sympathetic to the purpose of the statute to keep it private. Nobody wants to publish the names of rape victims.
But the issue is whether the law can allow this kind of confidentiality. Some people have gone so far as to say, this is so unique, we can't possibly have any law in New Jersey that says you must keep something confidential. That's just not true.
We're 0 for 1 in terms of the first example in which nothing's good.
No, that's not true.
Something going to happen?
Because we've had several other examples where we've had community notification without any problems.
So, in Warren County, of sanctions against those who certainly do what the statute didn't cover.
We haven't discovered who's done this yet. So,
we're investigating?
The case isn't over, yes. Yes, we are.
Jack, why are you shaking your head now?
Because what's wrong with this picture? I mean, first of all, as Peter pointed out, the statute is different. Megan's law was not upheld. Walentz's law was upheld because he rewrote the statute in about 50 pages of his opinion. The original law said that the Attorney General could vest with the prosecutors the authority to release this information as they saw fit. It further immunized civilly from liability any official who mistakenly gave the information too high, too wide, or too broad a dissemination. When the Chief Justice gave a stricter interpretation to the so-called likely to encounter deal, what he also said was, with all due process to due process, he said was, we asked for 2 things. We asked for notice and an opportunity to be heard before a neutral magistrate. And that's what Doe v. Poritz is all about. And the Chief Justice said, yes, you're entitled to those things. When we go to court to say, no, we don't think it should be a Tier 3 notification, then there is at least some contest. There's a lawyer representing the registrant who's saying, I don't think you ought to be able to tell the world. And if you are going to tell the world, could you put some restrictions on it? But when the registrant defaults, when he doesn't answer, it's on the Attorney General or it's on the county prosecutor. I'll notify whoever I deem appropriate under the likely to encounter standard. The judge really doesn't get involved. So when he's talking about keeping things confidential and drawing a parallel, let's say, with the juvenile statute, the juvenile confidentiality statute is written. The Chief Justice invited the legislature to write a statute parallel to the juvenile confidentiality statute when he wrote his opinion. I think the legislature ought to do this. We suggest that you do it. They haven't done it. The legislature was supposed to rework this legislation.
Well, let me ask you, Peter Banta, can the legislature do anything to restrict what newspapers can disseminate once they get a copy of the notice, in your view?
I think certainly in the case of a Tier 3 notice, there is such wide dissemination that you couldn't pass a constitutional statute that would forbid a newspaper from publishing what they learned. Nebraska Press versus Stewart, what was learned in a courtroom, the justices said you can't forbid people to repeat what they learned in a courtroom in an open trial. Same idea.
You could pass a statute that restricts what other people do. You know, we are going to let you know by statute that you're going to be a recipient of this information. Right now, a person gets the notice. Well, what's this? Well, there's a Megan's Law guy living in your neighborhood. And oh, by the way, if you give the information out, you're going to be held in contempt. You're going to be ordered to show cause. But if you write the statute, and the statute is comprehensive, and the public is informed that this is your responsibility, you want the right to know, you have a parallel responsibility not to disseminate the information, then at least you're on sounder constitutional grounds.
I am, because I think the public does understand, or they want to understand, how Megan's Law Law is supposed to work. We don't need another statute passed to let the public know how this law is supposed to work. Secondly, when you have a contempt order, it is my position that for purposes of disclosure or non-disclosure, that is as sufficient as statutory law.
Is it
your other guest said something that I think is slightly inaccurate, and that is, in the case that's at issue in the show, it only became wide dissemination when one local newspaper decided to make it wide dissemination. Megan's Law is carefully tailored by design. It's supposed to notice only those individuals who are likely to encounter the sex offender. Now, if, for example, we believe the entire community is likely to encounter the sex offender, we will go in and we will argue that to the judge, and hopefully the judge will agree with us. So we don't need newspaper notice to make a wide, broad notice. We can do that on our own based on the statute as it exists. One final point, if I may. What happened in this case, because the newspaper, apparently, by everything I've read, really aggressively sought out the flyer, really worked all of the sources, etc.
That's what journalists do.
They've come very close to actually inviting someone to be in contempt of court. That is far different than the case of someone who just comes across this flyer, or even if a neighbor picked up the phone and offered the flyer. I'm not hoping that occurs either, but there is a difference to what this one local newspaper did in this case to what I think the courts had envisioned might be a possibility in other cases.
Do you predict that this is an isolated incident, that the response that's occurred thus far and will occur in the future is going to stop this from ever happening again?
I hope it's an isolated incident. And as I began to say earlier, I had a very productive meeting with the editors of the major papers in the state. I got the sense that they want this law to work as well, even though I have no commitment.
But we're already dealing with goodwill, and that was already something the Supreme Court expressed skepticism about.
Well, the Supreme Court...
let me just ask you a question. Yes. In the legislature, there's some talk about a bill that would go in the opposite direction and basically throw open the doors and permit this. A, is it likely to pass? B, what's the administration's position on that?
I don't know if it's likely to pass. Our position is we hope that there will be no amendments to the law, substantive amendments, at least for the first number of months, where we can have some breathing room and actually implement the statute. I mean, we've never actually implemented the statute. Let's give law enforcement the opportunity to do that. This was one false publication or one improper publication out of 84 or 85 of them. So far, it's still just an isolated incident. Let's wait and see.
Jack Furlong, does this give any aid to those who are planning to renew the litigation, which we've already had 3 years on this statute?
Yeah, and the litigation will certainly, it goes on. Yes, it does, and for this reason. The Third Circuit, and indeed the Chief Justice, in his opinion in New Jersey, have complained repeatedly that there's an insufficient record below on which to amend the statute or decide whether or not to throw the baby out with the bathwater. And it's going to take one of these Tier 3 notifications with a contest behind closed doors, followed by the apple being thrown off the back of the cart and winding up on the front page of the newspaper, before an appellate court can look at it and say, well, we've now seen the trial, and the trial is fraught with error, and therefore we're going to have to go back and rework it. The ironic thing is, Peter and I can sit here and debate this with Peter in Newark, and we can all agree to disagree. But that's normally what happens in the legislative process, which didn't happen in this case.
Let me ask one question. Peter Banta, you represent a rather large newspaper in this state. Has that paper taken a public position on whether or not it's going to publish such notices?
I can't speak for that paper right now. I think the attitude of papers generally is that they will let their editors make that judgment at the time based on their evaluation of all the community factors that editors use whenever they make a judgment as to publication.
So it's fair to say that the newspapers in this state have not committed to not repeating this event. They're not
Absolutely not. I've spoken to the Press Association heads and their attorneys, and they want to let editors be editors, and the law should not tell them what to publish or not to publish.
Attorney General, where are we going to go? If the editors say they're going to pursue this, we know the News Tribune has said it's going to do it again if the opportunity arises. What's the future of the statute, given a determination on the part of journalists to publish what is otherwise newsworthy?
What I'm hoping the future is that this is an isolated incident, that the media will act responsibly. They know full well, the editors do, that there are other areas of the law, like rape victims and juvenile offenders, where they do exercise restraint. We're hoping they exercise restraint here as well.
Are you concerned at all that this incident is going to reopen litigation, or at least put the defenders of this statute at a disadvantage in further litigation?
I'm concerned that it might reopen litigation. I'm confident we'd win such litigation because the courts, both federal and state, that upheld Megan's Law did anticipate we might have something like this. They
were all hoping we wouldn't, but they said we might have something like this. So I'm confident we'll be able to beat back any additional challenge. I hope we don't have to go through that exercise.
Well, I think we're going to be back discussing this statute more in the future. I want to thank you, Attorney General Jack Furlong, Peter Banta from Newark. That's it for this edition of Due Process, but we'll be back next week with another controversial issue of law and social justice. Until then, for Sandy King and all of us here, I'm Raymond Brown.
Well, it was among the principal fears that a lot of people had when they brought this challenge. And although this is too serious a matter to say, I told you so, I think it is. I think it should cause everyone involved with Megan's Law to reflect and see if these notifications are going to go on, if there's any possible way to prevent this from recurring in the future. And if there is not, then maybe a renewed look on balancing whether it is doing more harm than good.
In the courts?
In the courts, by the executive, by the legislature, by all three of which have a hand in enforcing Megan's Law.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.